Texas is serious about DWI, driving while intoxicated, and the penalties can be stiff. An experienced DWI attorney can provide specific advice that pertains to your case and should always be the first action you should take if arrested for a DWI. In this video, we'll give you a general overview of DWI in Texas to better guide your decision to hire an attorney for your case. Texas DWI Definition. Driving drunk or under the influence of drugs is illegal in every state, but each state's specific laws are slightly different. In Texas, the term intoxicated has two different meanings. The most common is having a BAC, blood alcohol content of 0.08% or higher. Another way is having impaired mental or physical faculties due to the consumption of alcohol and/or drugs, even if your BAC is under the legal limit. For drivers under the legal alcohol consumption age of 21, any detectable amount of alcohol in the blood is prohibited, while commercial drivers aged 21 and over are limited to a BAC below 0.04%. Evidence of intoxication. It is crucial to understand that while your blood, breath, or urine can and most likely will be checked for the presence of alcohol, you may be charged with DWI based on other evidence of intoxication even if you are below the legal limit. This is typically based on the arresting officer's observations such as the smell or physical presence of alcohol, your appearance and behavior, and your performance on one or more field sobriety tests. DWI penalties. Texas has escalating penalties for multiple DWIs, and judges have a fair amount of leeway within the sentencing guidelines. In general, your first DWI will be considered a Class B misdemeanor with jail time of 3 to 180 days, a fine of no more than $2,000, and a license suspension of 90 to 365 days. Penalties go up significantly for a second DWI, and by your third DWI, you're looking at potentially being charged with a felony and facing 10 years behind bars. Subsequent DWIs carry even harsher punishments, potentially 25 years to life if you are convicted again after serving 2 DWI jail terms. Other factors can also increase DWI penalties, such as the presence of a child in your vehicle, a very high BAC, 0.15 or above, an open container, or any injury or death that you caused while intoxicated. Drivers under the age of 21 are prohibited from having any detectable alcohol in their bodies. Education and intervention. First-time DWI offenders may be placed on probation in lieu of or in addition to jail time and must attend a 12-hour DWI education program. Usually, the course must be completed within 180 days of the time probation starts, or your license can be revoked. Repeat DWI offenders are likely to be placed in a 32-hour DWI intervention program along with their penalties. This is a more in-depth program designed to encourage repeat offenders to seek treatment for their alcohol or drug issues. You must complete the program or your license could be revoked. Those who are under 21 and are convicted of DWI are normally ordered to complete either an alcohol education program for minors or community service. Whichever is ordered, it must be completed within 90 days to avoid a 6-month license suspension. In this case, you will also have a restriction placed on your license authorizing you to drive only vehicles with this type of device. Texas DWI laws are complicated and tend to side with the arresting officer. Because a DWI charge carries harsh consequences, it is vital to hire a DWI attorney immediately after your arrest. Your attorney can help you request appropriate hearings, communicate with court officials, negotiate a plea deal, and in some cases, even have the charges reduced or dropped. With so much at stake, choose an experienced Texas DWI lawyer with a proven track record of success. If you have questions, contact us today. And if you found this video helpful, then be sure to like, comment, and subscribe.